Okay, we're live now.
Okay. Shelby, you want to start by calling into the line? Do you want to start with that or not?
With our first applicant or?
No, I meant, did we have an open line for?
No, we don't.
Okay, not today. Okay.
No.
All right. Well, welcome. I am Justice Melissa Standridge, the chair of the 9th Judicial District Nominating Commission. Today, we are convening to fill the district judge vacancy created by the retirement this weekend, actually, of Chief Judge Joe Dickinson. I want to start just briefly before our first interview, which is going to start in 4 minutes. We have 4 candidates to interview. By reminding what we as the commission are required to do by statute. It is under KSA 20-2909. It shall be the duty of the commission to nominate not less than 3, no more than 5 persons for each office which is vacant, and shall submit the names of the persons so nominated to the governor. And that statute goes on to provide any person nominated shall have the qualifications prescribed in KSA 20-2903 subsection B, which states that persons nominated by the commission shall have the qualifications prescribed by law, which we've already screened the candidates for that, and shall be a person recognized for the following 5 things. And again, this is stated in the statute. Number 1, recognized integrity. 2, character. 3, ability. 4, experience. And number 5, judicial temperament. So those are the qualifications that are listed in the statute. After the commission has had an opportunity to interview the candidates, the commission will then have an opportunity to discuss each candidate's qualifications for the position based on the review of all of the written materials submitted by each candidate, the candidate's responses to the interview questions, and the reference checks conducted by each of you during the past week. After that discussion, I will call for a vote, and I will explain the voting procedures that I would recommend to the commission. Although I am the chair, I'm a non-voting member, and the procedures of voting, etc., are up to you as the commission. At this point, are there any questions? Okay, Shelby, it looks like we're 2 minutes early. Do you want to wait, or do you want to see if Mr. Lomas is on the line?
He is in the waiting room. I can go ahead and bring him in if we're ready for him.
Oh, I would mention one other thing that we agreed at the last meeting, and I think when the notice went out, that we prefer candidates or strongly encourage candidates or interviewees not watch the interviews of those candidates or interviewees that come before them, because this is live streaming and that would be an unfair advantage. And Shelby has drawn names out of a hat. This is what we discussed at the last meeting as far as the order that we go in interviewing the candidates. And so our first candidate is Michael Young. Thanks, Shelby.
Go ahead and bring him in.
Good morning, Mr. Lomas. Can you hear okay?
Yes, good morning, everyone.
And am I pronouncing your name correctly?
I prefer to go by Lomas, but either way is fine.
No, we want to go by what your name is. So Mr. Lomas, thank you. I'm glad I asked. Mr. Lomas, this is the 9th Judicial District Nominating Commission. And as you can see, everybody's name is underneath. The nominating commission is made up of 4 members elected by lawyers who are lawyers And then the other 4 are non-lawyers that are appointed by the governor for terms that usually bleed into the next governor. I want to welcome you and also thank you for applying. And at the beginning, what I'd like to do is provide you an opportunity for a brief opening statement to summarize why you believe you're qualified for the position. And after you're done with your opening statement, if you so choose, each commission member will maybe ask a question.
Thank you. Well, again, good morning, everyone. My name is Michael Lomas. I'm an attorney here in Newton, Harvey County, Kansas. I've been practicing now 20 years. My experience in the last roughly 10 years has been mostly criminal law related, but through the entirety of my career, I've done a wide range of law. I've practiced family law, juvenile law, probate, some civil. So I think I'm pretty well-rounded. There are some things that I'm obviously more experienced and feel more comfortable doing, but I believe I'm also a quick learner. I'm not afraid to try and learn something if I'm not familiar with it, or even just to ask questions. We have a lot of members, lawyers here in the community that have been very helpful. They're mentors. They're willing to, I guess, take questions when we have questions, and I'm the same way. And I think, frankly, my experience kind of speaks for itself. Two, I've been a Newton native pretty much my entire life. I've worked in this community almost my entire career. I practically grew up at the courthouse. My mother was a clerk there in the district court. I had a job there in high school when we actually had a physical law library. I worked there in high school, updating the books and the manuals, and that, I think, is kind of what fostered my I guess my belief that I wanted to practice law. As I said, I grew up in this community. I've worked with a lot of members of this community. With the amount of time that I've worked, I've met a lot of people. Some of the people I'm working with today are second generation clients or just people I've known growing up. I think my ties to the community give me some insight to what's going on in the courtroom, and gives me some unique perspectives that I think would be appropriate for a judge to have. I guess finally, I think in regards to my temperament and demeanor, I think the way I am would bring a lot to the table. I think I'm very patient. I think I listen well. I try to respect others in the courtroom. I feel that, those are some of the key factors a judge should bring to the bench, and I think I share those. I think I'm approachable, and I think, going back to my experience, I've worn a lot of different hats in the courtroom. I've been a defense attorney. I've been a prosecutor. I've represented people civilly. And I've also been a judge. I have experience not only through working as a municipal court judge for several years, but I've also been asked to pro tem in district court, where I've heard cases, I've done sentencings, I've done first appearances, preliminary hearings. So I'm familiar with the workings of the courtroom. I don't feel intimidated by it. And I believe that with all of that in mind, I believe I could be a good candidate for this position.
Okay, thank you. I think now we'll open it up for questions by the commission members.
Guess I get to go first. Good morning, Mike.
Good morning.
Nice to see you.
Good to see you too.
Is Mike okay, or Michael?
Mike's fine.
Okay. Mike, I know you've had quite a bit of experience as a municipal court judge, and maybe you have strategies there, but what strategies would you use or implement to run an effective courtroom as a district court judge?
Well, I think it's a team effort. We obviously have administrative staff and clerks that assist in scheduling, making sure paperwork is processed. I think it's just a team effort, where as a judge, we have to make sure that people are doing their jobs so that things run smoothly in the courtroom. I personally like to try to be as prepared as possible when I go into the courtroom, so I know what's going on, what's going to happen that day. And, even when I'm sitting on the bench as a municipal judge, I expect the people to be just as prepared. If we're scheduled for some sort of contested hearing or trial, I want to be able to proceed efficiently. I want to be able to get things done. I know delays happen, and I'm certainly willing to listen to why there may need to be a delay, but I try to be reasonable, but I also believe that, everyone needs to be prepared, and we need to try and move forward as efficiently as possible.
Thank you.
Mike, this is Tom Adrian. You mentioned having grown up in Newton. When I moved back to Newton, having grown up in Harvey County, I thought it would be an advantage. All of a sudden, half my relatives wanted work done free, and you've probably experienced some of that. But when
Sure.
you move to the bench, and particularly with your long-term lifetime term really in Newton, you're going to run into a lot of people that are either related to you or you've known, you sit next to in church or something like that. Have you contemplated that aspect of it? I mean, maybe not legal conflicts, but just practical conflicts.
I have, and I've run into that a couple times already through my career. I guess one, if I believe there is a conflict, even if it's a minor one, I would recuse myself from the case, just because, these people require to have, their fair day in court. Me knowing someone down the street, or, seeing someone that I know from the convenience store every day that I go to, that's not going to bother me, because it's a separate, I think I can separate work from personal. And, my job in the courtroom would be to hear the case, to make decisions based on what's presented, not my personal feelings about someone or their family. I think that's part of the job, is just being able to set some parameters about, what's personal, what's work, and be able to focus on the work part and make sure that you're fair and equitable, and that you don't have any leanings one way or the other when you go in.
Good morning, Mike.
Good morning, Jana.
I just wanted to ask you, I know you've had 20 years of experience in both municipal court and in state court. Can you share with us perhaps an example of a judge that you have appeared in front of, what qualities they possess, and who you would try to emulate in your position on the bench, and why?
I'm probably going to sound like a broken record, because I'm sure people have heard this answer before, but Judge Dickinson. Judge Dickinson has been a mentor to me through my entire career. I actually interned for him a summer when I was still in law school, and I find the way he acts from the bench, that's just kind of been, to me, the gold standard of how a judge should act. Judge Dickinson is fair but stern. He listens to people, but he's approachable. He has a lot of common sense, and sometimes sometimes there's a lot of common sense lacking in the courtroom. Those are the kind of the factors that I have tried to implement in my career. I know that whenever I've appeared in court, especially for anything contested, I always try to talk to the judges after the hearing to try and find out, what I've done, what I did well, what I could improve on, and any other input they'd like to provide. And frankly, so those are the things that just I'd like to try and, if I could, grasp from Judge Dickinson, apply if I were to take the bench in this particular case.
Thank you.
Mike John Robb, have you ever experienced hearing a set of facts or a story that then later turned out not quite to be true? And how do you, as a judge, keep from judging the case on the first set of facts that you hear?
Well, yes, I've run into that scenario before. I guess from what to answer your question, I would say that, unless it's a trial, don't make any firm decisions until you're asked to do so. I think, frankly, the judge's job is to listen, to gather information from the entirety of the situation, and then only when asked to, make your decision at that time after hearing everything. I mean, it's not uncommon, as you said, to have different versions of the same scenario, and you just can't jump on the initial set of facts and say, that's what I'm going to stand by. I mean, there are things that come up, they come up last minute, they sometimes are a surprise, but you just can't make a decision until you've heard the entire set of facts. And then only then can you really make the decision as to what needs to be, only then can you make the decision, is what I'm saying.
Thank you.
Good morning, Mike.
Good morning.
Amy Bauer. My question would be what you see as a frustration in this position if you would become a judge.
That's a good question. I think some of the frustrations I see sometimes are just a lack of being prepared. I know that COVID has obviously impacted the legal system over the last year and a half and has forced a lot of changes in how we do things in the courtroom. And, especially just taking it from my perspective as a defense counsel, a frustration is just sometimes not being prepared and things being continued, set over, and basically drug out. I know right now time is a important quantity in the courtroom just because everything's kind of been on hold and we're trying to take care of a backlog in the court system. So, when cases aren't getting resolved and then we're adding new ones, that obviously impacts everybody. But I guess my frustration is obviously just a lack of being prepared. Sometimes it's not your fault. It may be the client's issue or there's witness issues or whatever the case may be. But that's kind of one of the, I guess, big frustrations that I have, that at least in my opinion.
Michael Chip Westfall here.
Yes, Joe.
Prosecuting and defending, of those two categories, what's the highest in criminal cases? What is the highest severity have you handled either at both once as a prosecutor and one as a defendant for the defense attorney?
Sure.
And if you could go through those cases a little bit and how it was handled.
Well, as defense counsel, the highest level case that I have is a murder case. Actually, I'm working on a couple of them right now and they're both pending. So I don't want to say too much, but they're both murder case. One's an adult client, one's a juvenile client. So obviously those are very difficult. I will say that I've asked for assistance on those because I am a one-person office and I don't want my practice to suffer because of the time that needs to be allotted to those. But so I'm not afraid to ask for help. As for prosecution, if I'm just going off memory, it may have been, I believe, some sort of sexual related offense. It wasn't rape, but I believe it may have been a indecent liberties or case similar to that. I don't remember the specifics, but I do know it was a high level sex case.
Thank you.
The last one, well, Harris Perry. How do you set goals and manage your time?
Well, I manage time by scheduling. I make lists. I try and focus on what is of priority and set those first and try and just work down the list. Same with goals. It's just a matter of taking a look at what's ahead of me, what is the most important, and making sure that I address those in a timely fashion. In this profession, especially when you're dealing with a lot of clients, you need to make sure that they know what's going on, that, if they have a hearing coming up, that you're adequately prepared for that. And, showing up unprepared is just not professional. And so I always feel that managing, setting goals, setting reminders, taking time, even after hours to take care of situations, that's what's important. Making sure that those people's needs are being met so that they can have their day in court.
Has becoming a district judge in 9th Judicial District been one of your goals?
It has been. I think that's just something that after working in this profession for a while and knowing Judge Dickinson, just seeing how he's practiced, it has been a goal. That's part of the reason that I thought if I wanted to do this particular job, I wanted to get experience. That's why I sought out trying to at least becoming a judge even at the municipal court level, just so that I could have some experience making decisions like that. I've talked to people, tried to expand my practice areas just so that I have a little bit of flexibility and understanding of other areas that would be in front of a judge. So yes, it's been a goal for me, and I've tried to work towards that with some of my prior history.
Mike, I have one maybe follow-up question, but in the course of checking backgrounds for the candidates, it was brought to my attention that the statistics had been published for court volume and the workload. And I was told that Harvey County, the 9th Judicial District, has the highest volume workload of any district in the state of Kansas. Can you tell me your thoughts on that, what your work ethic is, and if you think that that's something that you are ready to face in the event you become the appointment?
I was somewhat aware of those statistics, and I can see it every day when I go to the courtroom. I see our dockets, and they are packed. Working hard doesn't scare me. I've worked hard my entire career. I'm not afraid of taking on goals, and I know this is a big one, but the way I see it is the 9th Judicial District has 3 district judges and a municipal judge, or excuse me, a magistrate judge. And, we work as a team. We need to work on getting those cases taken care of. We also are short on attorneys in our community. We have a lot of older attorneys. We don't have a lot of young attorneys coming in, and trying to find people to do that work is putting a strain on our bar. I certainly feel that trying to take care of this caseload as quickly as we can. And I'm not saying you rush anything through, but obviously trying to get things scheduled, making sure that hearings are taken care of expeditiously. Like I said earlier, I'm not afraid of working hard, working long hours. It's just one of those things that I've grown accustomed to having my current position. And I feel that I could bring that work ethic to the district court.
Thank you.
Mike Andros here. My question is, in today's society, there's a total disrespect for the overall judicial process. Do you have any suggestions on how we might improve that situation?
I guess one thing I might think, just to answer that question, one thing that might just be is just making sure that we are available to the public, whether it be people that want to come in and watch court and see how it goes, whether it's even the newspaper. I know the newspaper loves to write articles about what's going on in the courtroom, whether it's about the new drug court program that was just announced earlier this week, or, if there is a high profile case, making sure that the public has access to these cases so they know what's going on, that it's not just a big secret, that it's not just, a bunch of people making decisions that affect the community. I think just basically having open communication, being able to express, to some degree what's going on in the courtroom, and just making sure people have access to ask questions of either the judges or anyone else that might have information they need. I think it's just one of those things. We're just trying to keep an open door, for lack of a better term, and not making it seem so secretive, which I think that's some of the concerns that people have.
Thanks.
Mike, I have a follow-up question based on your statement about wanting to be part of a team, working with the other judges. What unique or maybe new perspectives do you think you have that you could share with the team, that you could offer the team?
Well, I think just based on my work experience, I probably bring, just knowing some of the prior history of the current judges, I probably would have more of the criminal experience that I could bring to the table. Not that they don't do that on a regular basis, but that's kind of what I've done almost 18 years of my career. So I think I bring some of that to the table. I think just based on my connections to the community, I think I just bring a unique perspective. I'm, 45. I've worked here, grew up here. I'm a minority, so I think I bring an extra kind of viewpoint as to where they may not have that.
Mike Chip Westfall, and you briefly mentioned that we're going to dive into a drug court type program, but in the next few years, what do you expect and what changes? You attend CLE trainings and see what goes on in other states. What would you look to in the future to bring in new programs to the court system that could speed up the docket and better serve the community as a whole, to prevent social loss and financial loss to the community?
Well, drug court was probably the biggest one that I think is a key factor. Substance abuse is such a big issue in our community and just in all communities, but I think right now that's our biggest focus. The other thing that I'd like to see is trying to maybe do something more on the mental health side of things. Mental health issues are something that I see on a regular basis. They're sometimes tied in with the substance abuse, and resources can be scarce. And I'm not sure exactly what we can do through the court system to try and implement anything to assist with the mental health aspect other than trying to maybe coordinate with Prairie View and seeing what resources might be available. But that would be one thing I'd like to see. I'd also like to see some more services provided to our juveniles in the community. Right now, with a lot of the changes in the legislature about juvenile offenders, we really don't have a lot of resources for them. It's either put them on probation or send them to JCF. There's no middle ground, and there's a lot of kids that fall in that middle ground because of substance abuse or mental health or family issues. I'd like to see what we can do to change the law to kind of bring back some more resources to assist children, whether it be offenders or even our child in need of care kids. I think we're letting them down, and anything we can do, I don't know if we can do it on the local level, but at least on the state level, trying to get more resources for them, more foster homes, just so we don't have these issues that we're seeing in the news these days.
Thank
Mr. Lomas, I'm going to ask one question. It seems like, and you say in your materials that most of your work is in criminal or in sync in child in need of care and probate matters. And I know you briefly mentioned this in your opening statement, but do you have any experience with civil litigation like medical malpractice or car accidents or torts or any kind of, and if not, what would you do to get up to speed on that?
Sure. The type of civil, I haven't done any civil work such as the ones that you've laid out. I think mostly it's been like landlord tenant or, credit card, debt that, judgments, things of that nature. But as I was stating earlier, one, I'm not afraid to learn. I'm not afraid to catch myself up to speed on civil cases that may come before me on the bench. I know that, as I stated earlier, if I have questions, we have other judges that definitely have more experience than I do in those areas, and I'm not afraid to ask questions or to reach out to other judges in Kansas that I might be referred to. But I think it's just the bottom line is you have to learn, you have to get to a certain base to be comfortable with doing those types of cases. And I'm not afraid to do that. I think, again, the other thing is I'm not afraid to ask questions. And I think that's something a judge just has to do sometimes. If you're not familiar or if you're not sure, you ask questions, even if I've seen our judges do that in the courtroom when they're not sure about the current status of a statute or, what their options are on a probation revocation. It's okay to ask questions and, learning from that.
Well, it looks like we're almost out of time. Would you like to take a moment to sum up?
Well, I guess first and foremost, I thank all of you for your time this morning. I certainly think that my responses today give a good idea of what type of person I am and what I could bring to the table. And I certainly hope that it helps make a decision today for all of you.
Thank you very much, Mr. Lomas.
All right. Thank you very much.
Shelby, do we have Mr. Bravi in the waiting room?
You.
Okay, is everybody ready for the next interview?
Yes.
Okay, I'll bring him in.
Thank you.
Good morning.
Good morning. Can you hear okay?
I can. Can you guys hear me okay?
Yes, we can. Thank you. Mr. Bravi, my name is Melissa Standridge, and I am the liaison between the Supreme Court and the 9th Judicial District Nominating Commission. And the commission is made up of 4 members of the legal community and 4 members of the non-legal community. I want to first thank you for applying and give you an opportunity to provide a brief opening statement to summarize why you believe that you are qualified for this position. And after you're done with your opening statement, we'll open it up for commission members to ask individual questions.
Okay. Well, thank you, Justice Sanders, for that kind introduction, and good morning to all the members of the commission as well, and anybody else, I guess, that is watching from home via YouTube. So when I got the email last week from Ms. Hardtarfer saying that I was selected to interview, of course, I had a lot of emotions, as people could expect. You know, I was excited, I was nervous. And then I kind of got down to the business of thinking about why I would be the best candidate for the position. And I thought about it when I was running at the gym and when my wife and I were going for walks in the evenings. And I came to the conclusion of a few things, I think, that make me the best candidate for for Judge Dickinson's position. And one of the things that kept coming back to me is, you know, I've spent a lot of time practicing in Reno County, and I'm the deputy public defender there now. And one of the things that Judge Chambers always used to say to the jury before basically when he was in orientation with them, is that our system of justice, our legal system, while not perfect, it is the best system in the world. But it only works if everybody feels like they have had a fair opportunity to be heard and present their case to a judge or the jury. And I think one of the things that makes me the strongest candidate for the position is I have that deep commitment to fairness. And that may seem like a small thing, but it's not. And the reason is, you know, I've been fortunate enough to have been practicing about 10 years at this point, and I've done over 30 jury trials and a number of ranging from, you know, attempted capital murder cases with complex legal defenses such as mental disease or defect defenses, on down to, you know, the standard run-of-the-mill possession of drugs, as well as, you know, civil cases as well, family law primarily. And I've had the experience of being treated fairly in front of the court, and I've had the experience of not being treated fairly by the court. Unfortunately, my experiences of being treated fairly far outnumber the negative experiences that I'm sure a lot of the counsel have had at different points in their career as well. And it's that deep sense of commitment to fairness is one of the reasons why I think I would be the best candidate for the position. But a judge can't only just be committed to being fair and impartial, they also have to have a command of the rules of evidence. And I have been practicing in the courtroom for about 10 years at this point. And from those jury trials and the numerous evidentiary hearings that I've had over the years, I do have that command of the evidence. A judge has to be able to make quick decisions and keep an open mind. And that's something that I feel that I can do and I can bring to the bench for the 9th Judicial District. And it's because of those experiences that I've had, not just in my legal career, but also prior to my legal career. After college, I volunteered after Hurricane Katrina for AmeriCorps, and I led a team of 10 doing disaster relief for a year down in the Gulf Coast after Hurricane Katrina. And it was, I had the opportunity to see people at the lowest of their lows at that point and get to know people. And then as my role as a public defender, I've just realized as well about how important it is that we treat everybody with kindness, dignity, and respect. And I think that's something that a district court judge should have, because you see all different kinds of people that walk into your courtroom, and not everybody obviously is going to be is not going to be happy with the outcome of the case. That's just the nature of our business. But what I can tell the commission is that anybody that walked into my courtroom would know that I would provide consistent and fair rulings and treatment before everybody. That's one of the things that is important to me. And I think that garners respect. And I think it's all those reasons, the diversity of my experience, both in my law career and just my general temperament, that I think would make me the best candidate for the position. So, and I would welcome any questions that the commission may have of me.
Good morning, Justin. My name is Amy Bauer.
Good morning.
And you share with us experience mostly in criminal, and you said a little bit of family law. Could you expand on any other civil experience? And then if that's more limited, let us know how you plan to overcome that lack of experience in maybe those other civil areas.
Yeah. So what I can tell the commission is for the last 4 years, I have also held a private law business. I worked for a year with Boyer & Price Law Firm. And then I left to go back into public service, primarily as a lot of people will know, student loans for law school are not cheap. And I'm engaged in the public service loan forgiveness program. But during the time since then, I have done family law and probate, of course, as well, and landlord-tenant law as well. So I would say, while 75% of my practice has been in criminal law, that translates great to civil as well, because of the rules of evidence and how you have to handle a case. But I have had I have tried cases to Judge Clinda, as far as divorce cases. I've been in front of Judge Hilgers for probate matters. I've handled a variety of those matters as well. And one of, I think, my greatest strengths is that I consider myself a student of the law. I'm not one of those people that I just assume that I know the answer. What I do is I research the law. And I think that's very important for any person that's considering a career on the bench, is that I think that you should not just assume you know everything, because I think problems can happen when that occurs. So, I've, as far as the case, I've handled paternity cases, child custody cases, and I've been continuously engaged in that. And frankly, I've had to limit what I can do on the private side, so that I can make sure that I'm providing the best representation to all people. I don't engage in any defense work outside the public defender's office. That's not allowed by BIDS, the Board of Indigent Defense Services, who I work for, but civil cases are allowed. And so I guess my answer is I do have that experience. I do believe it's pretty well-rounded. And could I learn more? Absolutely. And that's one of my greatest strengths, and that's how I would overcome it, is that I would continue to learn. I'm curious by nature.
Justin Hurst, Terry, how do you set goals and how do you manage your time?
Yeah, that's a good question. I've found over the years that I am I'm the most productive when I have several things going at one time. If I think about over the course of my career and just life, what I have wanted to do, and one of the things that I always come back to is I always want to try to help people, and so a lot of my goals have surrounded that, and to serve our community. And I look at the things that are important to me, and that's probably the most important thing to me. And when I set my mind to something, I accomplish it. As far as my legal career, I make sure that I review all cases, and I'm diligent. At times, it could almost be viewed as a weakness, I suppose, is that sometimes I get too involved. I work too hard on them. But it's the truth is that I am always working to try to accomplish those goals. And it's just one step at a time. You set a goal and then you work towards it. I mean, I did that with graduating, of course, from college, from law school, working with AmeriCorps, and then just moving up through my career. I think the best evidence of how I set goals and who I am is just by what I've done in the past. Hopefully that answers your question.
Do you have a description of what the ideal judge would be?
I think the ideal judge is somebody that is fair and impartial. I think the ideal judge is somebody that can be kind but yet firm. A judge has to make tough decisions, and they have to instill the respect from the community and from the local bar. And I think that, like I mentioned earlier, I've had those experiences, unfortunately, where they've been negative. And there's times where a judge can have a chilling effect on justice. And that would not be my goal. My goal, and I think what I would want to be the kind of judge that would give everybody that fair opportunity to be heard. I experienced that a lot with Judge Chambers and Hutchinson, and I would want to do the same thing because he always gave people that chance. And when they walk out of my courtroom, I'd want them to know that they were treated with dignity. Now, that doesn't mean that I wouldn't make those hard decisions, or because that is the nature of the job. And as a public defender, I have to do that. I have to talk to people and look at them in the face and tell them that they have to go to prison for a number of years. Those aren't easy conversations to have. I've made the hard decisions as a prosecutor where I had to make charging decisions, that affect people's lives. And I would take all that in consideration. And I think the ideal judge should have some humility. They should understand that they don't know it all, and that they're willing to learn and have that open mind. And sometimes that's easier said than done.
Thank you.
Justin, this is Tom Adrian. I have what I consider to be some practical questions. One is, you're aware, I assume, that you would probably have to move your residence if you were appointed.
Well, Mr. Adrian, I do live within the 9th. So I live within McPherson County. And so it's my understanding.
I apologize. You had your office address as Hutchinson, and that's what I was looking. That's right. You do live.
But I live in McPherson, and I drive over to Hutchinson every day.
The other question is, you indicate you have considerable student debt and you're in a forgiveness program. Would your appointment as judge change that forgiveness program at all, or how would that work?
Oh, not at all. So as I understand it, district court judges are employed through the state of Kansas. It's considered a public service job, and that would still qualify for the public service loan forgiveness. And for those on the committee that aren't familiar with the public service loan forgiveness, basically what that is that you have to make 10 years of on-time payments and be employed continuously in a public service job. And then after that 10 years, and it's you are making payments, and I can tell the committee, unfortunately, for a significant period of time, those payments are heavy, but after that 10 years, I'm very close to it at this point, that the loans would be forgiven. So I've never missed a payment. I think, frankly, probably on anything, whether it's student loans or any debts that I've incurred is what I should say.
Justin, John Robb, have you ever experienced hearing a story or a set of facts that then turned out not quite to be as first told? And how, as a judge, would you keep from believing the first presentation you get? How do you keep an open mind till the end?
I think my experience as a public defender are lead into that very well. I meet with a lot of people, hundreds throughout the years, at least, or every year, many. As many of you probably know that a public defender's caseload is high. And you have to keep an open mind when you are meeting with people. And I do that when I meet with my clients. And I don't just assume that I believe exactly what they're saying. Some people do, but I try to keep an open mind based on what they tell me, and then I compare that to the facts of the case. And then you present that to the court. I think that having preconceived notions, whether when you go into a client meeting or whether when a judge comes into the courtroom and has already made preconceived rulings or notions of what the case is, I think can only lead to folly. I think what a judge needs to do is keep that open mind until all the facts and evidence are in. I think that that's the best way that I've done that, and I have to do that nearly on a daily basis when I'm meeting people, either in my office or at the jail. And frankly, you have to do that in family law cases too. Divorces and paternity actions, as the committee is aware, are some of the most emotionally fraught cases that the bench deals with and counsel deals with. And I think when you're meeting with those people, you also have to keep that open mind as well, and not just assume whatever somebody's telling you is the truth. I think you have to work to get there and keep that open mind.
Hi, Justin and Elliot here. You mentioned earlier that you've been treated unfairly by a court, or what you would have perceived as being treated unfairly. Can you describe what that was? And then if you were a judge, how you would avoid that in your courtroom?
I think that kind of goes back to Mr. Rob's question about keeping that open mind. I think I've had experiences throughout the state at different points. And like I said, it's minor. But the experiences I've had is when the rules of evidence have not been treated equally to both litigants. And there is nothing more infuriating. And my wife tells me there's nothing that I complain about more than being treated unfairly in court for my clients. And without getting into specifics, but it's really just that fair wielding of the rules of evidence. Objections should be sustained for both parties in exactly the same manner. A judge shouldn't have a preconceived notion over which party should prevail and which party shouldn't. Of course, there's the standards of evidence and the burdens that each party have to share, but how the judge makes those rulings and how they move forward with that really provides that fair system where everybody can feel like they have been basically had their day in court. I have a lot of clients that they get convicted of their offenses, and if we go to jury trial, I would say a majority of them, and they get convicted, they feel like that I did the best that I could for them and that they have had a fair opportunity to be heard. And that means just as much to people to know that they are actually being heard. And that's what I would want to do as a judge, is I would want to make sure that everybody that came into the courtroom knew that I provided consistent rulings and orders as is appropriate, according to the law, and make sure that everybody was treated with that dignity and respect that I think they deserve.
Justin, I'm Jana McKinney. In reviewing your application materials, I noticed that the bulk of your...
You just went silent.
Sorry, I was just going to ask, it looks like in reviewing your documents that you submitted, the bulk of your 10 years in practice have been outside of the McPherson County 9th Judicial District. I did not see listed in the associations that you are currently a member of the McPherson Bar or the Harvey County Bar. Have you been a member or participated actively in those bars in the past?
No, I haven't. When I was working here with Boyer and Price Law Office full-time, that was the first year that I was in private practice. And it was, frankly, I was what I considered, at least at the time, too busy to do it. What I have done is I am engaged in the community. In McPherson, I also volunteer with Habitat for Humanity. I'm the vice president of the McPherson Area Habitat for Humanity Board. And for those that aren't familiar, We build houses. We help people give a hand up, not a handout. And so as far as my community service, I have been primarily involved in that organization while I have been a lawyer as well. I have and I do practice mainly domestic and civil cases within Harvey and McPherson counties right now. But I haven't been engaged in the Bar Association itself.
Thank you.
But I wouldn't be opposed to that, obviously, if I was selected as the candidate.
Justin Chip Westfall here. As your involvement in the court systems and handling a lot of indigent care, that type of thing, Harvey County has a teen court, and we also start in October a drug court. But what would you advocate for to assist the entire judicial system over the next 10 years to improve services and rehab or education or care of children over the next 10 years? What does the 9th Judicial District, or in your case, the Reno County area, need for services to better serve court cases?
Yeah. There's several things with that. And, believe it or not, there is a lot of bleed over between clients that I have that are in Hutchinson, clients that I have in McPherson, and clients that I have in Harvey County and Newton as well. So the client base and the challenges that each one of those communities face share a lot of things in common. We're just close. And so that's kind of the nature of our area. I do think a drug court is an excellent opportunity that should be more utilized, especially over the next 10 years. What I can tell the committee, it's been my experience as a public defender that, a lot of the people that we come into contact with, and a very, very large amount of my cases are dealing with the possession of drugs, and particularly methamphetamine and heroin. And a lot of those people are good people. They unfortunately have an addiction. And I think that the establishment and more jurisdictions, and I have worked with, when I was in Salina, the Salina Public Defender's Office, I did work at times with their drug court system. And what I can tell the court is or the commission, is that in particular, the drug courts can save lives and help people get off of drugs. And I think the sooner that those programs are widely adopted throughout the state, the better our communities are going to be. Our economies are going to thrive more because people are not going to be as addicted to substances. And it's a hard challenge. I think anybody that does our work knows that. And it's a struggle within the community, especially right now with heroin and other issues. So I would advocate for the use of the drug court program. I think that's a big one. As far as sync courts go, obviously those are important, that families are connected with services within the community as well. And I think trying to maintain those relationships that in the family unit, it also kind of dives in with drug court as well, because a lot of families that are experiencing trouble that are in sync court, those parents oftentimes have drug addictions. That is a very common thing that I have seen with my clients as well. And so I think connecting the sync court parents and to those services as well would help improve our local community as well.
Does anybody have any follow-up questions? At this point, Mr. Bravi, if you'd like to take a moment to sum, we would be glad to hear that.
Well, one, I just want to thank the commission for giving me the opportunity to interview with you today. I know that that you have a hard job in front of you to choose some names to send to the governor for appointment. I think that one of the issues that I just want to impart upon to the I almost wanted to say to the jury, but to the commission is just that I do have that strong sense, that commitment, a deep commitment to justice. And some people may consider my age, I'm 38 at this point, a negative, but it's really a positive for our local community. I have, if you ask people about me, you talk to the various references or people that weren't even on my references, I think they'll tell you that I'm one of the hardest workers they'll meet. And that is something that I would carry on to the bench as well. The community and the local bar could count on me to provide those consistent, fair orders and the rulings and appearances in the courtroom. And other than that, I just appreciate the time that you guys have spent with me this morning. And I guess that's all we have. And I'll be interested to hear when the decision of who is going to be sent to the governor will be made. So
that decision likely will be made today after the interviews are over. So you should know today.
Okay. So, well, thank you again. And if nobody has any other questions, I guess I'll log off at this point.
Okay. Thank you, Mr. Bravi.
Okay. Thank you. Bye.
At this point in our schedule, we have scheduled a break. We're about running 4 minutes ahead of time, but we'll go ahead and maybe reconvene at 10:25 so that we're prepared and in front of the computer to start right at 10:30. What I normally do is turn off my voice and turn off my video. So it would look like this, but it's up to you what you want to do. Just remember that during our break, we're still recording live on YouTube. And I'll see you in about 13 or 14 minutes. Mike, we have about 2 minutes to go. Are you there? Shelby,
Uh-huh.
do you have Mike's number in case we need to call him?
I do. Mhm.
I think we should call him.
Okay.
Oh, there he
Okay,
is.
I'm here. I'm back.
All right, great. Welcome back, everyone. So it's 10:30 on the dot if we're ready to bring our next candidate in.
I will bring Mr. Morris in.
Thank you. Good morning, Mr. Morris.
Morning.
How are you?
I'm fine. How are you doing?
Fine. I am Justice Melissa Standridge, and I am the chair of the nominating commission for the Ninth Judicial Circuit. Sorry, for the Ninth Judicial District Nominating Commission. And I welcome you today to the interviews. I want to start off by thanking you for applying and giving you, if you would like, an opportunity to present an opening statement to summarize why you believe you are qualified for the position. And after you're done with your opening statement, then each of the individual commission members may have questions.
Okay, certainly. My name's Levi Morris, and right now I'm the Barton County Attorney in Great Bend. I grew up in Newton. I played sports and graduated from high school in Newton. My first legal job was in Newton at Cornerstone Law across the street from the courthouse. My dad lived in Newton until he passed away 3 years ago. And even this year, I come back to Newton 3 or 4 times a year. I'm the second trumpet player in the Newton Mid-Kansas Symphony. And I open at that because the people who applied are a Newton prosecutor, a Newton defense attorney, a McPherson attorney, and a Great Bend attorney. And I know at first blush, people who do not know me would say, well, why is this person both out of county and even out of the judicial district applying for this position? So that's my connection to Newton. I was there in 2011, 2012, and 2013, practicing in front of Joe Dickinson before I left at that time. I've applied for this position probably because I think I'll enjoy it. I hope I'd be good at it. And that's the result of the experience I have over 10 years. I started in Newton in private practice. I learned enough about bankruptcy law to know I don't want to do bankruptcy law. I did enough personal injury practice to know I don't want to do personal injury practice unless I'm going to be a specialist at it. Did a lot of divorce while I was in Newton. I came to Barton County as an assistant at the time and primarily did juvenile cases and did some adult misdemeanor and felony work. After about 18 months, I left the Barton County Attorney's Office and opened my own office in Lyons, Kansas, and did criminal defense work and pretty much domestic work for about 4 years. And then at the end of 2018, right after my dad passed away, the Barton County Attorney job came open. The person who had hired me was still around, but they had a new county attorney. The county attorney resigned after a public dispute with the sheriff. And I was a sole applicant for that job in December of 2018 and was reelected by the voters last November. So in that time, I've gone from being just an assistant county attorney in those responsibilities. And as I think you probably saw in my application, I do seem to place a great deal of emphasis on the difference between an assistant county attorney who prosecutes misdemeanors and juveniles and has a lot of discretion and just kind of focuses in on that case. And the change in roles as being the county attorney. As a county attorney, you cannot spend 40 hours a week burying your head into your own files. You have to meet with commissioners routinely. You have to meet with your chief of police routinely. You have to meet with your sheriff, and particularly in Barton County and my county, in the situation I came into, I meet with my sheriff regularly. You simply have to be an administrator. And given the list of challenges and responsibilities or duties that a district court judge has, I seem to think that that was fairly relevant. I don't recall word for word my answer, but the number of judges in the state of Kansas simply hasn't changed very much in 40 years, but divorce filings have gone up, criminal filings have gone up, and at a time when I think consolidation is probably not far around the corner, it's going to be ever more important that district court judges be masters of their own schedule. I mean, you can't just sit in chambers and read Friday morning Supreme Court opinions and issue a few opinions. You have to be in charge of your own district, and every county is different, every district is different, but we know that some counties are busier than others because judicial assignments haven't changed. So those are the 4 components or parts of my experience and practice over the years that I think is a broad range of experience. I did list in there one time, I made a mistake that I want to catch. I think in one of my answers, I've practiced in over 20 counties in the state of Kansas, and I either meant to say or did say somewhere in there almost a third, and that was a misstatement if I put that in there.
At this point, we can open it up for questions by the individual commission members if they have any.
Okay, Mike Andros here.
Mike.
In your application, sir, you were asked if you wanted to provide letters of support. Would you explain to the commission why you decided not to do that?
Certainly. I can't provide much more elaboration than I put in my answer. Being an out-of-county district or out-of-county applicant, I desire to keep my application about as secret as I could. Now, I say that because I didn't think it would not become known, but I'm an elected official in a county where I'm a little afraid that once my commissioners, my sheriff, my chief, my own office manager, my own secretarial staff learn that I've made an application, people are going to start to get nervous. Literally in my own office, once some people found out, there's just this natural concern. Are you leaving? My office had to endure 2 or 3 years before I showed up of wondering who their boss was going to be. Because in 2016, there was an election. And then with the public fight with my predecessor, the office was not, they weren't, stable is not the right word, but they weren't comfortable because you never knew who was going to take over. And I intentionally, knowingly didn't want my office to start getting concerns. Now, it's going to get out. I got a question from an attorney this morning who called me, who would have been one of the people I would have asked to submit a letter. And he supported me in the past. And he actually asked me just this morning, I've heard you applied for that position. And my first response was, that's correct. And I'm trying to keep that a secret. It's just the sort of thing that's going to get people distracted and cause disturbances in my office. The second consideration is that with you guys being in McPherson and Newton, how many of you know who Tim Keenan in Great Bend is? Tim Keenan writes a letter. Okay, and I don't mean to suggest no one does, but maybe not everyone would. Same with Tom Burscheit. Now, Tim and Tom are both as old as dirt, and both of them publicly supported me in my elections in the past and would have been some of the first people I went to. But sometimes a letter from an attorney 95 miles away that you don't know a lot would carry less weight than if I asked an attorney there in Newton. So I just, I'm not under any disillusion that it wouldn't get out. I just didn't want the building to start panicking and have to walk into every docket and explain to somebody new why I played out of county. So that was my goal, knowing that it wouldn't stay a secret forever. I wanted to delay that release of information because if, for example, you guys announced that 3 names are going up today and I'm not one of them, now I can tell everybody when they find out later, it's already done, it's already passed, don't worry about it, I'm not going anywhere.
Thank you.
Levi, this is Tom Adrian. Tom Bierscheid's a
Well,
friend of
Tom.
mine. I'm going to tell him what you said, but
Tom is turning 80, and with the passing of his office partner, he's losing an assistant, and he's having to face retirement this year simply because he doesn't have an assistant who can do e-filing. So I don't think it's going to be the first time Tom felt older than dirt.
okay. All right. In the references I heard from and talked to about you, they all commented, had the same kind of words, that you went into the county attorney's office and these were their words, not mine, cleaned up a mess. And so I assume by cleaning up a mess, you made some people unhappy and made some people happy. And so I'd like to have you describe for us what the mess was and how you dealt with the unhappy people and the happy people.
Okay. I'll just warn you, it's a long answer. So I came into office in December of 18. Amy Meller, who was the county attorney for all of 2017 and 2018. Amy was an assistant prior to that. When I was an assistant here, there were 3 prosecutors. From January of 2005 to January of 2017, Doug Matthews was the Barton County attorney. Doug was an attorney in my office until about 4 weeks ago. Doug's a nice guy. Doug was somebody who politely was never cut out to be in charge. Good attorney, knows how to read the law, but he was never, his boss retired, so it was the next man up, and he won an election and he was the county attorney. And slowly but surely, cases piled up, and we elected a new sheriff. His name's Brian Bellender. in the 2012 election. Brian would have come into office January 2013. And there's just a lot of grumbling. And I wasn't here, I can't speak too specifically about that long ago. But by the time 2015, 2016 rolled around, there were just a lot of rumbles in the community that somebody needed to run for county attorney. I know a few names were thrown out there. I know some people thought when I left, I was going to come back and run, which wasn't never my intention. But in 2016, there was sort of an arrangement that the county attorney and the assistant county attorney would swap places. And that's part of what I said earlier, that my office has had to endure this question of who's going to be in charge? Who's going to, is anybody going to get fired? Am I going to enjoy working for the next boss? And luckily no one filed. So there was a smooth transition. An assistant county attorney that everybody liked became the county attorney. The county attorney slipped into an assistant's role, admittedly, probably with a retirement date in mind. And everybody's pretty optimistic that a change in the guard would happen, or everybody was optimistic that there would be a change, because subtly, no one was really overly happy with the Barton County Attorney's Office at that time. And I don't mean to say that it was public, but you talked to law enforcement at the time, and they were never really that thrilled. And then sometime in 2016 or 2017, while arresting a suspect, I want to say burglary, but I might not be positive, my sheriff, now and then, smacked a guy in the back of the head. And when I say smacked a guy, he did not punch him, he did not kick him, he didn't hit him with his baton, he did not engage in any excessive force, but he did touch him, and it was on a body camera with officers of the Great Bend Police Department. And so it got reported and got looked at, and that's a messy situation. That was not appropriate. Is it a crime? Well, the Barton County Attorney's Office at the time decided it was a crime, or it was something that they couldn't ignore, and charges were filed. Sheriff didn't like having charges filed against him. He didn't like the office already, and at that point, I would probably be accurate in describing it as war. So once that happened, battle lines were drawn. Somewhere in that time, and I don't think I could provide an exact chronological order, Barton County Attorney's Office had two embarrassing dismissals. I want to say speedy trial because everybody understands what speedy trial is, but technically it was a detainer act, which is a speedy trial creature. And so somebody who was charged with attempted murder that was brought back from Wisconsin, Minnesota, Michigan, from one of those states, was let out of the jail, a free man, his case dismissed because the state of Kansas failed to prosecute his case in a timely fashion. And the jailer who let him out is the sheriff who's charged with the crime. So that became very public, and it was very embarrassing to have such a high profile, or maybe not high profile, but a very serious charge handled so poorly. And then around the same time period, there was another case, an individual, Jeffrey Rankin, was charged with Jessica's Law crimes, looking at 25 to life if convicted. And once again, there was a failure to bring him to trial as required by law. And in his case, technically speaking, some other charges came up later, so the Jessica's Law convictions had expired in terms of jurisdiction and speedy trial, but some charges that were discovered or filed because the evidence was discovered after the initial filing were able to survive. So he was ultimately convicted and sentenced to 10 years when he was looking at 25 to life on multiple charges. So once again, you've got a sheriff who's at war with the county attorney's office. They've charged him with a crime, and he's telling everybody publicly it's an incompetent office and we need to clean it out. After the two speedy trial dismissals, the sheriff's case eventually went to a jury trial, misdemeanor for ill treatment of a confined person, I think. It's an obscure misdemeanor that rarely gets filed. People wondered why it wasn't battery. I would say a general practice, if you have a case where you can't prosecute it because of a conflict of interest, a case like that, you probably go to the Attorney General's office. Well, the Attorney General's office has a division that will prosecute official misconduct, but they do not look at misdemeanors. So the Attorney General's office was never a real consideration for special prosecution of the sheriff's case. I would say next you go to your neighboring county attorneys, the ones in your district, the ones nearby. The county attorney at the time went to Chase County, which the last time I thought about it, I think is 5 counties away. I mean, Barton, Rice, McPherson, Marion, then Chase County. And 5 counties away, it's a 2-hour drive to find a special prosecutor. Well, the politics of it all, the prosecuting the case in the press, the sheriff says, you know, this has been a political witch hunt from the beginning. County attorney's out to get me to cover up for the incompetence of their office. And now they went and found and handpicked a prosecutor to special prosecute this case because any attorney with a set of common sense would not prosecute this. And the accusation was that the county attorney found an old friend from law school who would do him a favor and prosecute it. And ultimately the misdemeanor case with the sheriff went to trial and the sheriff won. So as you can imagine, this had all been very public at the time. Sheriff's out on the east end of the courthouse with his attorney and news cameras and just, I've won. This trial was a complete waste of taxpayer money, a poor decision by somebody who's incompetently ruining their office or running it poorly. And I want to say a couple of weeks later, and I've talked to the sheriff and we talked about this letter, he sent a public letter to the county attorney and the commissioners and to paraphrase, says, I'm coming for you. I'm going to tell the Barton County commissioners that they need to seek independent counsel to look into removing you by recall or ouster. And then I would say within a week, the Barton County attorney said, you know what, the sheriff's a bully. I'm not going to be able to get along with him. This isn't working. I'm resigning. And that's the political turmoil that I came into. I would say that the Barton County commissioners during the sheriff's election, I don't know if it was a proclamation, but they formally on the record said, we support our Barton County sheriff, which implicitly says we don't support our Barton County attorney. There was just a lot of acrimony in the air. No one was happy. The commissioners had a decades-long dislike with the county attorney's office. You know, commissioners want to be talked to. They want to know what's going on. They don't like hearing complaints and having county attorneys that refuse to meet with them except that one budget meeting a year. So that's the political environment I came into. We had 2 speedy trial dismissals, a backlog of cases. We had not a trial docket, but a preliminary hearing docket that was a complete mess. Cases languished. One of the sheriff's complaints at the time was that his jail was at maximum capacity. I think his capacity is 101, 108, and he's got a little bit of wiggle room, but he was at a point during that public battle that he's being charged with a crime. He's letting dangerous people out of jail while his jail is at maximum capacity, and we're wasting taxpayer dollars putting people out in the neighboring county jails. And all that was because the county attorney allegedly, or the claim was they just couldn't move cases. So that was, I think that's the big talking points of what I walked into and what I had to do. And so, you know, the commissioners, the sheriff wanted to see changes in the office. They wanted to see cases moved more smoothly, more efficiently. They didn't want to see speedy trial dismissals. Those better have a good reason to happen. Generally, there is no good reason for a speedy trial dismissal. It's not to say mistakes don't happen, but you better have a good reason for that stuff. And so, I said the sheriff's jail was full maximum capacity. People were spending 6 or 9 months in jail waiting for a preliminary hearing. To get into the weeds on the attorneys, a lot of that was intentional. A lot of prosecutors across the state will delay a preliminary hearing because they don't have their KBI lab test back. The problem with that is it's not a real excuse to delay a preliminary hearing because a field test on your dope is sufficient for a probable cause bind over.
I think what I'd like to hear is the second part of the question, which is you obviously made some people mad.
No, I don't think so.
You didn't make anybody mad. Okay.
Well, I've made a few people mad, but again,
how did you handle that is what I'd like you to address for us. How do you handle people that are going to be unhappy with you?
Did anybody say anything specific? Because I know the first thing that comes to my mind. When I ran for election for judge last year here in the 20th, Mike Keeley retired after about 38 years. Again, I had the sheriff's support and a lot of law enforcement support. And out of nowhere, suddenly there was a group of people on Facebook suggesting that I don't prosecute sex crimes. That's about the only thing when you say that I must.
Actually, no one mentioned any. I was assuming that if you walk into a mess like that, I was assuming that there were people that would like what you did and dislike what you did. And I'm really handing you an opportunity to tell us how you would handle people that may be unhappy with your decisions.
Okay. It just depends. This is going to sound incredibly arrogant. I don't know that there were that many people that I upset when I came into the county attorney's office. That's how bad things were. I mean, majority of law enforcement officers I talk to say, I know a difference because we used to get 60 subpoenas a week and none of these hearings would go. And now you service 6. And when we get them, the hearings go more often. I mean, law enforcement has overwhelmingly been pleased with the transition. My own staff, no one's left. No one's been unhappy with the changes and left and brought anything sort of a minor thing to me. So I don't know that I have a great opportunity to say, you know what, this is a confrontation I dealt with in the past and how I resolve conflict resolution. I mean, really, things were so bad, the bar was so low. I don't know that very much of what I've changed has displeased anyone.
All right.
Levi.
Yes, ma'am.
This is Amy Bauer. Just after you navigated so much turmoil, why is it now you would want to apply for a position in the 9th Judicial District and move?
It's a unique opportunity. There have been judicial openings in other districts and counties, and I never for once thought about applying for them. They come across the email, so-and-so's retiring. I've never once considered applying for an out of county or out of district job. And the exception goes back to just my opening statement. I grew up in Newton. I wanted to come home to practice in Newton. I was able to for a few years. And then the circumstances were a better opportunity with somewhere else. And I don't mean to say that I couldn't have stayed, but it just wasn't the best thing for me to do at the time. So it's just a unique situation to return to my hometown. If this opening were in McPherson, if it were in Hutch, if it were in Wichita, I would not apply.
Hi, Levi and Elliot here.
I am.
How would you, or what strategies would you implement to effectively run a courtroom?
It depends on the needs. What I can tell you that I observe here is that in Barton County, we have 3 district court judges, not unlike McPherson and Newton. 2 of them are based in Barton County. 1 is an at-large in the 4 surrounding counties. They have to reside in office there. And in Barton County, my position is that the judicial assignments are not adequately doled out. We've inherited an old tradition going back maybe 15 or 25 years where in Barton County, 1 judge does the probate and civil docket, which is not overwhelming. 1 judge does the domestic docket, which is not overwhelming. And 1 judge does the criminal docket, which is overwhelming. And that's not to be critical of that judge. That's to say that somehow we've just, the water's boiling and no one has grabbed the frog out of the water. So when you reach that point of capacity of your schedule, when you are scheduling jury trials 9 months out, you have to, you can't take anything off the table. You have to start with double booking of jury trials, maybe triple booking of jury trials. You have to make sure that, my opinion is a district court judge has to maintain their own calendar. Judge Clinda does it. If I'm scheduling a hearing with John Clinda, most of the time he did it in the courtroom and we talk and he says, Mr. Morris, how about Tuesday morning? Sorry, Judge, I've got a docket in Barton County. What about Wednesday morning? Sorry, Judge, I have a docket in Pratt County. He goes, Mr. Morris, I've given you 2 dates, pick one. We have that sort of situation in Barton where we have attorneys who practice out of county and I'm busy. And unfortunately, a judge has to be in charge of their calendar and you've got to have more than that in my mind. Continuances are part of doing business. They're normal, they're ordinary. Doesn't mean they need to get granted without real good cause. We have dockets in Barton County that, are different than some of the ones in other dockets, but you have to cattle call some of your cases. You have to cram 20 attorneys into a room because not every single case can have its own half-hour hearing. We are at a point in Barton County where we're gonna, everyone has changed because of the pandemic and not just this hearing, but Zoom has become a reality for most of us. There are conversations about having more hearings and more dockets by Zoom because in rural counties, district court judges may have to drive an hour and a half to get from the population center to one of the outlying counties. And as I said a minute ago, we have a judge who has to office and reside in the outlying county. So for them, every time they have a Barton County case, they're driving in. Spend 3 hours on the road for an hour and a half hearing. These things, drain into time. So we're having conversations about integrating Zoom into, starting off with status hearings and dockets and, pleas by consent to the defendant. And then the next challenge is going to be whether or not you could have, can you have a motion to suppress hearing by Zoom? Obviously, you're going to need the defendant's consent. Where's everyone going to be at? I don't think we're too far from suggesting that it's just going to be normal that evidentiary hearings are over Zoom. Not that I'm in favor of it. I'm actually kind of opposed to it, but just one of the strategies that people have to impose. I think scheduling's a lot of it. And this is my experience and my biases, but I've seen, as a county attorney here, sometimes in a defense case, the number one strategy is to delay. Like, we don't want to say that publicly, but you're a criminal defense attorney, your client walks in and you tell them you're out of jail, we're going to delay. What does that mean? We're not in a hurry to do anything. What does that mean? It means we're going to continue your preliminary hearing. Why? Because we're going to delay. Because as time drags on, the silent truth that nobody wants to say is that most prosecutors lose focus on older cases where people are out on bond and haven't gotten in any more trouble, and they suddenly get more preoccupied with the new case of the day. And so defense attorneys admittedly love to delay their cases. File continuances. I'm unavailable. We're at a point in Barton County to where we've had to start filing objections. I don't care if the defense attorney says they're unavailable. What county are they in? What's the case number? Because I literally don't trust some of my defense attorneys. They'll just say they're unavailable because in the past, judges have never questioned them and then cases drag on. So whether it's dockets, whether it's technology, or whether it's a judge being more aggressive than, or being as aggressive as I think you should be to maintain or manage your calendar, some of those things are all at play. I know too many judges who, my assistant does the scheduling. Well, the assistant's not going to badger the attorney's assistant to say, what do you mean they're unavailable on a Friday afternoon? Do you mean they don't want to work? Because I understand that nobody wants to work on a Friday afternoon, but that's not unavailable. And so unfortunately, there's just some subtle gamesmanship that goes into it, and judges have to be masters of their own calendar.
We have about 2 minutes left.
Okay. John?
Yep, I have a question.
Yes, sir.
Levi, we have 4 applicants for this position. 3 of them live within the district and appear to be ultimately qualified. Other than the fact that you'd like to move back to Newton, why would we go out of district when we have 3 candidates that are qualified in district?
There's a long, I shouldn't say long. My understanding is, when Judge Walker retired, when Judge Anderson retired, there's a long tradition of the 2 Newton seats going to Newton attorneys and the McPherson seat going to McPherson attorneys. The ones I've observed personally, that was true. So you're right. You have Jason and Mike live in Newton and are just, good applicants and would be fine judges, I mean to say. And so if you're sitting there looking at a McPherson County candidate versus an out-of-county candidate, is the McPherson candidate going to move to Newton? Is he going to stay living in McPherson County? It's just a tradition or an operating procedure. There's no rule. There's no statute that says it. It's about your personal preference. Is that a strong preference? I mean, is the fact that I'm going to move to Newton better or worse than the fact that one of the candidates would continue to reside in McPherson County and break that tradition? I don't know. That's not for me to say. If there's an order of priority, these things are, to use a phrase the lawyers use way too often, it's a totality of the circumstances. We're not just looking at a bar number. There's more to it.
Mr. Morris, we're almost out of time. You have maybe like 30 seconds to sum up before next interview.
I get it. I don't mean to suggest that you should ignore your local candidates, but I don't know the fact that I'm out of county would be a reason not to give it strong consideration. And there's a lot of things you have to consider. And all I can say is that I understand some of its tradition or preference, and that's just a part of your discretion to go with.
Anything else? Sam?
I'll do it for me.
All right. Thank you, Mr. Morris.
Thank you all.
Shelby, I think we're ready when you are.
Okay, I will go ahead and bring in Mr. Lane.
Good morning, Mr. Lane. Can you hear me okay?
I can. Good morning.
I'm Justice Melissa Standridge, and I'm the liaison from the Supreme Court to the 9th Judicial District Nominating Commission. And we have 8 members, 8 voting members. I don't vote. 4 who are attorneys and 4 who are non-attorneys who live in the district. I want to welcome you and thank you for applying. And I would also like to give you an opportunity to provide the commission with a brief opening statement to maybe summarize why you believe that you're qualified for this position. And then after your statement, individual commission members may or may not ask questions.
All right, thank you. Well, good morning, and thank you for this opportunity. I believe the qualities that make me a good candidate are, one, I have a solid foundation based on my education and my experiences as an attorney and outside of the legal profession. I graduated from law school, magna cum laude, and from there, I spent many years advancing my education even while in practice. It's important to me to keep current on case law and changes in statutes. And when those changes do occur, as you can see from my application, I try to give that information out to the rest of the legal community. I have a calm disposition. I am able to listen and to handle stressful situations. And although calm, I do have the ability to take charge when necessary to make sure that control is kept and things don't get out of hand. I have a great compassion for other people. I think a lot of this comes through private practice and learning that even as a prosecutor, defendants are people who have their own lives and their own problems and things that led them to the position they're at. And part of that is to make sure I'm fair in all dealings, knowing that following the rules is one of the most important things, and that we're not here just to win at all costs. I also am a very good problem solver. Starts with my engineering background and the technical side of everything, but a good application to the law, because you have the laws, the statutes, and then you have the evidence and the factual scenarios. And just like any other problem, you're trying to apply those rules to the facts and come out with a just and fair decision. Along with that, I want to advance the community and help protect the community. And that goes beyond just the mere working cases through my office. Last year, I joined a group and we're developing the Harvey County Drug Court program. And with this program, we look further into just a criminal case. We look at how people's background and behavioral health issues have a great effect on addiction. We're trying to find better solutions than just prison for those offenders who are having troubles and struggling with that addiction. So I believe overall, with the experiences I've had and the education and the knowledge that I've obtained over the years, I would be a great candidate for the next district court judge.
Jason, I was one of the people who checked your references, and I would be able to state from my checks with other folks, to a person, everybody says you are always well prepared. And I thought that was a great statement, and it wasn't, it was held universally by everybody I talked to. My question would be, have you ever had or experienced where somebody tells you a story or gives you a set of facts and that then turned out not quite to be the right story. So as a judge, how do you keep from believing the first presentation you hear and keeping an open mind until you have to decide the case?
And when it comes to that question, that's common in my practice. We get police reports and statements from witnesses on scene. And then when we get into hearing, we learn of new information or changes to the statements that were previously made. And knowing that just because the initial statement says one thing doesn't mean that there's other sides of the story, or that the perception was even off, or the troubling fact that someone was just dishonest from the beginning. And how we handle that is we don't take everything at face value. We wait for all the information to come in, and if we're in the middle of a hearing and we know that maybe someone's being dishonest, we take a break and we make sure that the court knows and presents that information. And as a judge, I think it's important that I would listen to every side to collect all the evidence and not have a predisposed decision as to the situation until it's time for me to rule. And I think that takes great patience to do. And I believe I have that patience to wait before forming any opinions until I know all the information.
Thank you.
Thank you.
Jason, Chip Westfall here. On your career that you've had so far, it is predominantly in prosecution. So I think every police officer that is sitting on this panel can tell you when attorneys begin, they start at traffic and work their way up. So what's the highest level of felony case have you been handling? And how much experience do you have in the upper end of the of those category of cases to work through all of the court rulings, Supreme Court opinions, procedural steps to make sure all the I's are dotted and the T's are crossed? And how does that transfer to this position you've applied to, but then you now have to expand it to like the family court issues, civil issues, that type of thing?
So in my career as a prosecutor, the highest level cases were 2 separate capital murder cases. On each of them, my office did seek the death penalty. So in those cases, because of the severity, the number of motions and the motion practice is quite extensive. We cover almost every single pretrial motion, from suppression of evidence, suppression of statements, down to what clothing is allowed to be worn during hearings, and other type of issues. So we handle a wide range of not only procedural and courtroom decorum, but up into all the constitutional rights, making sure that our case is solid and that the investigation was done correctly, and responding to any attacks on that investigation beforehand. I went through the motion practice on both of those cases. In addition to that, I have gone to jury trial on a first-degree murder case. There are a lot of issues that arise in that type of case also. And then the jury selection in that case was quite extensive. And the law that applies, making sure we're under the right theories and the right level of mens rea in those cases. In addition to that, I've handled numerous child sex crimes cases, many violent felonies, including aggravated robbery and kidnapping charges, and all the way down, like you said, to the simple traffic cases, where I even still handle a few of those every so often when needed. So with that experience, I know that motion practice is definitely important. There's a lot of pretrial issues that, if not handled correctly, could have a very real impact on the trial stage. And to make sure that everybody gets a fair trial, we have to do the motion practices right. And then when we get in trial, we have to make sure that we're following the rules of evidence and making sure that the jury is instructed appropriately. Now, how that applies is every other case has the same rules of evidence. They have the same courtroom procedures, and they have motion practices. I have had some experience outside of prosecution. I spent some time in private practice where my main caseload actually became family law between divorce, child custody, and child support cases. I didn't know anything about family law when I started my practice. So it took time and it took effort to make sure I looked into the law, talked to other family law attorneys to learn procedures, and to get to a place where I felt comfortable practicing in the area. I believe the same would be in any kind of law I haven't practiced yet. I think the only one really was the actual civil side with corporations and businesses. The only experience I've had in that arena is I did an internship in law school where I spent a summer working on a summary judgment motion with a private firm out of Wichita on a contract issue. So I have a little bit of experience, but no litigation experience in that type of civil arena.
Thank you.
Hi, Jason. I'm Jana McKinney. I would like for you to tell me and the panel somebody that you have practiced in front of that perhaps you see as a mentor to you and a judge that you would like to emulate in the way that you would present and hold your court.
And not to brown nose too much, but I've developed a huge respect for Judge Wilder of our current courts. Over the years that she's been on the bench, I've seen her demeanor, her ability to work with everybody who comes into her courtroom. And what I appreciate most is when she's given an issue, she wants to make sure that she understands the issue, researches it, and comes out with a decision that's appropriate for the case. And even though I may not agree with the decision, at least I can respect it because she put the effort in and analyzed the case. I felt comfortable that I may have lost in that situation, which is okay because at least I was heard and the judge did the right thing and came out with a reasonable decision. She also is working with me on the drug court program and encouraging me to continue with those outside efforts because being a judge is more than just sitting on the bench and looking at cases. It's looking into programs and how to make the community better as a whole. So she is definitely someone I would like to emulate and practice.
Thank you.
Thank you.
Then Ann Elliott here, kind of along those same lines, what strategies would you use in your courtroom to make it run efficiently?
So the biggest issue I see the courts facing today is a huge number of cases and a stagnation of the system, especially in these times. I believe one practice is definitely systems management and calendar control. I did a lot of this in my engineering studies. Industrial engineering is all about systems management. It's trying to find where are the bottlenecks and how can we make the processes more efficient and easier. But there's always the counterbalances. We can't cut out everything and lose the ability to protect the rights of everybody and rights of defendants or any other parties who appear before the court. So it's definitely a balance. I believe with encouraging not only cases to move forward, but with resolutions prior to trial. And I think Harvey County has done a great job at that by introducing settlement conferences beyond just the civil arena. We've come to many resolutions outside of trial on tough cases through that settlement process. I believe adopting good calendar control, good courtroom control, and options outside of jury trial will help with the big caseload that we're all facing these days.
Thank you.
Thank you.
Hi, Jason. My name is Amy Bauer. Could you describe maybe some of the biggest frustrations that you anticipate in this position?
I believe one of the biggest frustrations is I'm always trying to prepare myself and be ready for court, but coming into a situation where attorneys aren't prepared and they're not doing their duty and caring about the job to the point they're representing their clients effectively. I believe that's very important. I believe that's going to be a tough situation to handle. The other thing is my worries are always going to be whether I'm making the right decision. Although I will do my best to listen to the issues and research, there's always going to be that question, was that perfect? And that's just a struggle, especially someone with like me has some anxiety. And once that perfectionism is realizing never going to be perfect. But as long as you try, as long as you put in the effort and you come up with a good decision or a well-reasoned decision, we can move forward. And of course, there's checks on the system to let you know if you did make a mistake.
Here's Terry, Jason. Based up, following up on that, is there any specific aspects of the position that moved you to apply for it?
So I think the difference between being an attorney and being a judge is that advocacy portion of it. As an advocate, I have an interest to make sure that my client, in this case right now, the state of Kansas, is represented. It doesn't always mean that my argument is the best decision in a case, but it's the best decision for the state at the time, or when I was in private practice, my family law client, or the criminal defendant. What excites me is being able to be the neutral position and to take in the facts and use those analytical abilities I've developed to come to well-reasoned decisions. It's also being able to meet a wider portion of the public as other people come into my courtroom. As a prosecutor, we kind of get bogged down because all we see every day is the crime and the worst of the worst, and knowing that there's other things out there. And even today, when I was waiting on a hearing, seeing the adoption case before me and seeing the joy that we don't get to see as often in our cases, that's the exciting part, is being able to branch out and do other things.
Jason, this is Tom Adrian. You mentioned one of the frustrations you would possibly see would be attorneys who would show up unprepared. And I know that never happens, but hypothetically, if it did, what would you do about it?
It really depends on the struggle that I'm seeing. I think the first step would be to take a recess. If we're not in a position where a person's being represented effectively, we need to take a break because there's a major issue, and to proceed does nobody justice. It might be an in-chambers meeting, a consideration of a continuance, because I understand that sometimes we're not prepared and we can't avoid it. I've been in those situations myself, and my tact was always to make sure I asked the court for some time to make sure I'm prepared. And if you don't abuse that privilege, if you don't ask the court numerous times, I found that most judges will give you some leeway and give you that time. And I think that's the important part, because we all have our life struggles, and sometimes we're not at the top of our game or perfect. But to try to go into court and proceed without having the preparation to go forward it's just not the right thing to do. And we need to take a step back and decide how we're going to handle that situation.
Kind of following up on that, Jason, what would you do if you had to master an unfamiliar area of the law in a relatively short time frame?
And that's the struggle with trying to be perfect and come up with the right decision. Do you take a time out? Do you take recesses? Do you take the matter under advisement? And if your time limit is short and you can't do that, you always can fall back under your prior knowledge and experience. You run into the situation where you don't know the background, but there's a common logic throughout the law. And as long as you're basing your decision on fairness, and of course, this is prepped by you don't have time to do the extra research. It's following the logical steps that you have in other areas to make sure that your ruling is consistent, consistent with constitutional rights and consistent with the case law in other areas, to apply that, to make sure that even if it came out to be the incorrect decision, at least it's a well-reasoned decision that you can support by other areas.
I have one follow-up question that I suspect I probably know the answer to, but I wanted to ask, statistics have recently been published that show that the 9th Judicial District has the highest volume caseload of any district in the state. And I think the number was like perhaps 2,639 cases per judge. I suspect in the county attorney's office, you're responsible for a lot of those filings, but does the fact that it is such a high volume court give you any pause in applying for this position? And how will you handle just the pure volume of cases that go through the court?
And with that question, I feel like I should apologize for generating a large portion of those cases. But the caseload does not scare me. It doesn't give me anxiety because I handle a large caseload. I've been here for about a decade now, and I've always carried around 200 cases on my calendar outside my other responsibilities. Even becoming county attorney, I've kept a higher number of cases and added a whole lot of other responsibilities on top of it. I think with that experience and even my prior experience at Sedgwick County, when I was in the DA's office, we had a large caseload there. And even in my beginning stages as a traffic attorney, every single day we'd sit in court with over 100, 150 people waiting to have their case heard. And there were 4 prosecutors and sometimes down to 2 a day. So not only the day-to-day management of large caseloads and creating those efficiencies, but the overall caseload and trying to work out the cases and keeping control of the calendars. I believe I have the experience and the knowledge to help facilitate the large number of cases.
Thank you.
Thank you.
Mike, or Jason, a follow-up to my question earlier about handling attorneys who may not be prepared. The first or second time might be okay. What about someone who is routinely unprepared or unprofessional in your courtroom? How do you handle that or address it in that situation?
And there's obviously 2 options in that situation. First is addressing it in the courtroom itself, or at least in my own chambers or in that position. There's also the ethical responsibilities. And if someone is not prepared or unprofessional to the degree they're violating the ethics rules, I would have an obligation to report that to the Office of Disciplinary Administration. As a judge, it's also my duty to make sure that our attorneys are upholding their ethical standards. As well, it'll be my duty to hold up my own ethical standards. And failure to report that would be a violation of my own ethics. So to handle in court, like I said, my tact would usually be trying to handle it outside the courtroom, off the record, addressing the situation. if that didn't work, or if it was so much of a problem, or to a high level of unprofessionalism, then we do take to the next step. We address it on the record. There's possible contempt findings depending on the unprofessional conduct, but definitely reporting to the right authorities to handle the ethics issues.
Thanks, Jason.
Thank you.
Jason Chip Westfall, and you've mentioned this, and I mentioned it with some of the other interviews. You know, you were involved in the onset of the new drug court, but what's the future of district courts in the next 10 years? What do you see that needs to be done to help district court judges and maintain and manage and lower the caseload, but also put social value back into the community?
And for courtrooms themselves, its access to the courts is definitely changing, and it's changing rapidly. As you know, today we've moved to a lot of televideo hearings and going along those lines, where we rarely saw that in the past. Now, giving back to the community also, just like the drug court program, finding better solutions than what we're currently using, knowing that a person with addiction is going to have a higher chance of recidivism to commit those financial crimes or other crimes that go along with the addiction, not just the possession of the controlled substances. And whether we're using our current tools such as probation or incarceration appropriately, when we see that we're not getting the answers or we're not solving the problem, we will look elsewhere. So we looked into drug court and found that there was larger reductions in recidivism in that area when there was closer supervision of the person with the addiction, where the groups were coming together and working together between the treatment providers, the supervising agencies, the courts, and the attorneys. I can see this definitely expanding. The other main issue that we see that's very prevalent are mental health issues. We have a severe shortage of mental health resources right now. That's definitely an area that needs to be improved, and something that I think the courts can help address. You know, we could pick the easy route. There's some mental health courts, but I think for an answer that's kind of a cop-out because it's just drug court with a different focus. But it's making sure that we're including the mental health portion in our probation cases, and making sure that there's follow-up and that there's compliance. So as the areas expand, I think in our community, both Harvey County and McPherson, it's addressing addiction, addressing mental health are the two major issues. And we have found that both of those issues run hand in hand with each other, as addiction can either, use of controlled substances can cause a mental health issue, or the mental health issues can lead people to the use of the substances. And finding an overall solution that makes our community better, instead of seeing the recidivism and the constant turnover of cases and people coming back to court that we see today.
Thank you.
Thank you.
Jason, it looks like we have about a minute left. If you want to use that minute to summarize or conclude, that would be fine.
I just really appreciate having the opportunity to speak with the commission today. I believe that you have several good candidates that you're looking at. I hope that I become one of those candidates that you find was qualified and would recommend to become the next district court judge. With my background and my experiences, I think I have the ability to run a courtroom, to listen to everybody who comes before me, not to jump to conclusions, and to make reasonable, just, and fair decisions. Again, I thank everybody for your time and your service for doing this part for our communities.
Thank you, Mr. Lane.
Thank you. And I'm assuming you'd like me to sign off. Yes,
Yes, thanks.
thank you.
At this point, we did not schedule a break, but if anybody would like to have a break, just let me know. Are we good, or do you want a break? Hearing no request for breaks, we'll move on. At this point, what I'd like to do is open up the floor for discussion about the qualifications of candidates. I'm going to go ahead and repeat what I said at the beginning of our meeting, which is in KSA 20-2903B. Persons nominated by the commission shall have the qualifications prescribed by law for such office and shall be a person of recognized, number 1, integrity, number 2, character, number 3, ability, number 4, experience, and number 5, judicial temperament. And again, those are the qualifications that are listed in our statute. And with that, I will open it up for discussion. I know that we have split off 2 members, each doing kind of follow-up based on the written materials, follow-up with individuals who have worked with our candidates and individuals who were listed as references for our candidates. So if you, we can discuss that, and we can all discuss information about the interviews. So with that, I'll open it up.
Chief Justice, would you again go over the rule on what we're going to send? We have to send up so many, or we can't send up? Go over those quick rules again.
Okay. Kansas statutes annotated 20-2909. It shall be the duty of the commission to nominate not less than 3 nor more than 5 persons for each office which is vacant.
Thank you very much.
And I mean, I can, you know, we can talk about the voting now. You know, I mean, based on my experiences with other commissions, usually, you know, you would start with a vote for your top 3 candidates. And we had agreed to vote by a show of hands. And then based on the number of votes, we can whittle it down from there. So again, I'll open it up for discussion of the candidates. Does anybody have anything they want to share based on calling references or background information?
I'll share a little bit, Justice.
Thank you.
I talked to 4 different people altogether, all of them in the criminal justice system in various ways. Only one of them only knew the candidate, Mr. Morris from Barton County, which is understandable since he doesn't live around here. But anyway, of the 3 locals, there was no negative on any of them that knew those, but there's some preferences that they had, and that they advised me of theirs, and the 3 here in McPherson and Harvey counties is the ones that was most recommended. I did some follow up on previous or current employment on Mr. Bravi, and the attorney down there is in charge with the defense group down there. Sarah McKinnon was a very strong supporter of Mr. Bravi, and she's known him for about 10 years. So the three living in the jurisdiction, from my perspective, meet the requirements. A little concerned with only 10 years of practicing for Mr. Bravi.
You know what, I think you cut out at the end. You have a little bit of concern about the 10 years for who?
Mr. Bravi,
Okay.
that would be the only thing, although he's a lot of experience, especially on criminal trials, defense attorney. But anyway, since we're supposed to send up at least three, that's the three I would support.
Okay. Anybody else want to talk? Yes, John?
I agree with Harris. I think we have three qualified candidates within the district. I think that was likely obvious in my question to Levi. As I talked to numerous attorneys in the district, I picked up no negatives on any of the three in district candidates. So I would be supportive of sending the three in district candidates to the governor.
One thing that I would share in talking with the several attorneys I talked with is kind of along the lines of what Mr. Rob said, that should we even consider an out-of-county candidate if we have three qualified within the county? And that language appears in some of the other releases, such as like the 25th Judicial District vacancy. That language is actually in their release that you shouldn't consider anyone outside the district if there's three qualified within your district. So how that is interpreted might be something we want to discuss, or just something that I wanted to mention because it was asked from some other attorneys that I talked with.
And of those three or in district, if we submit those three, are we going to provide any preference as to 1, 2, 3?
No, we don't do that.
Okay.
The statute just requires that we forward three for the governor's consideration, 3 to 5. I mean, I suppose you could. I guess there's nothing to prohibit it. So actually, we could provide her with the voting. But it would get very complicated, and I was not prepared to have like a rank voting. But we could certainly, because you'd have to kind of, instead of just voting, we'd have to do rank voting.
Right.
So, yes, John.
I think in the past, the commission has not selected a preference amongst the candidates we submit to the governor. I know of instances where individual commission members have provided insight to the governor outside of the commission after the proceedings, saying to the effect, I participated in this and I have a preference of X, Y, or Z because, but I don't know that the commission has formally ever ranked their submission or that would be appropriate.
Yeah, Chip.
I kind of concur that we stay within district because we do have enough qualified people, and I nothing against Mr. Morris, but I think we're pretty good. I'm concerned about Bravi's experience of time. Jason has been in the county attorney's office a great deal, being a county commissioner. He's made some changes in how that office has occurred and can manage. He's got management experience with that. Been involved in our putting the drug task force back together 2 or 3 years ago, and the other programs that he's put in to get the docket moving and making Newton a better social experience for people to grow up and have business here. I've known Michael Lomas since probably shortly a few days after he was born. He was a rugrat on the second floor of the courthouse. Janet can say the same thing. He's a quality person in our community also, and has been involved in the leadership of the defense team, the different offices that provide attorneys for that, and in the community, and has prosecutorial some experience and judicial or as a judge. So those are my top two. We have top three, and that's where I'm comfortable at. I don't care to rank them.
I agree with that. I think that we have 3 qualified candidates in the district, and that's the ones that we should send to the governor.
If I could clarify a little bit, this is, since I'm one of those in the category older than dirt, fourth privilege of sitting in on naming the judge. We have always considered any out of district applications, and to me that didn't make any difference if they would have been qualified. And I'm not saying that Mr. Morris is not qualified. I just, the 3 that are in district is my preference on being meeting those qualifications to the best of the candidate. That's where I'm at on that, and over the years, but it's not all bad. But big part of it is you just know the people better if they are in the area, immediate area.
You know, this is Tom Adrian. I was not vested with the responsibility of investigating Justin Bravi, but in calling references both listed and unlisted, I had 2 people tell me, comment just sort of offhandedly that Justin Bravi is certainly qualified and is a good candidate. And I think that, to me, that sort of obviated the fact that he's only been practicing 10 years, and he has impressed people enough to have them voluntarily recommend him. So, and John, I don't want you to hold against Mike Lomas his reference to older lawyers in Harvey County. I was worried that you would take offense there, but you obviously haven't. So.
Tom,
I
you
feel
got
like-
there first. I was saving it to get you a little later.
I knew you were. That's why I mentioned it.
I feel like Mike and Jason pretty well sort themselves to the top fairly quickly, but I am curious for whoever did the references on Levi Morris to give me some more information. I'm born and raised Newton, Kansas, and I have some sentiment towards that. And I don't think the fact that he's out of district would automatically disqualify him from consideration. So if somebody could share with me what they found out on their individual references, I would appreciate the input.
Well, I was, and Mike Andrews and I were, and you know, everybody I talked to, again, both listed and unlisted references, said that he's qualified to do the job. A couple of them would sort of offhandedly say, but I don't know he's your best candidate, and I didn't really dig into that too much, but the references I think gave some concern about judicial temperament. And so other than he was qualified, he's capable of doing the job, I think his interview showed that he was clearly able to navigate the law and all that. But the temperament part of it raised some question.
That's helpful. Thank you.
I could comment on that too. One of the locals that I talked to that did know him was very cautious, but he did say he's a little different. And left it.
Well, I don't know how to explain. One of the personal references that he did list said that when he was a little scared when he became county attorney because of his immaturity. He says he has gained some over the time that he's been county attorney, but he has concerns about his maturity. So that's where it came from.
I had two out-of-county attorneys call me and express judicial temperament concerns, as Tom has indicated.
I would agree with what Chip had said earlier with and Jana with the top three. With everybody I spoke to, although I wasn't charged with anyone but Mr. Lomas, everyone had input on all four candidates when you speak to them. And I talked with both Harvey County and McPherson County individuals and lawyers, and everyone had very positive things to say about Mr. Lomas and Mr. Lane, both being very prepared, very calm, having a good demeanor at all times. And they've both handled high-level cases where that's not always easy. And they deal with a lot of different individuals who might have different struggles. And so I think both mentioned their ability to be patient and their references, and even people who would not be specific references for them would mention that. And I think for me, judicial temperament and demeanor in the courtroom, because you interact with so many different people, are very important. And Mr. Bravi, although has only been out essentially as long as I have, he has a lot of experience in the courtroom. 30 jury trials is a lot, particularly given the last year and a half where we haven't had any. Mostly, I think in Reno County, they have had a couple since COVID, but that's a lot of jury trials, and that's good experience dealing with the public and the judicial system and knowing how to handle those cases.
Justice, would a motion be appropriate?
Oh, yeah. So I'm waiting for Tom to tell me what the Roberts Rules of Order are. So, I mean, when we're done with discussion, yeah, we can take a vote. We could do it by motion or.
I would move that we forward Lomas, Lane, and Bravi to the governor.
Oh, I think maybe we should take, well, is this how we want to do it? I was going to recommend that what we do is vote for your top three and see if there's any kind of disparity, like if there's any ties or anything like that, to kind of see where we stand first. And that way, it seems like it might be a little more, instead of just, because if you don't vote for that panel of three, you know, it's hard to vote for something else. Like if you have a different panel of three. What do you guys think?
I don't have any problem doing it that way. We can just go ahead and vote individually and then go with John's motion.
Okay.
Is that all right, John?
I'm good with whatever.
Okay. So what we decided to do is vote by hand, and I'm going to go in order of how they interviewed. And what I'd like you to do is vote. You get to vote 3 times, and we'll see where we stand from there. So you get to vote for your top 3. So when, you get to vote 3 times and raise your hand, but you don't get to vote 4 times. Is there any confusion there, Jana?
I do have a question. I don't have a question as to the 3, but I'm curious if I can abstain and only vote for 2, even though 3 would actually go up.
The rules don't address that. So I would say if you want to do that, that's fine. I know that that's done in other judicial nominating districts. So if you only want to vote for 2, or if you only want to vote for 1, that's fine. So thank you for that clarification,
You.
actually. So you can vote for 1, 2, or 3, and this is going to be our initial vote to try to narrow it down to at least 3. So if we haven't, if they're all even, we could send up 4, but we'll address that situation when it comes up. I would also ask, I will tell you this, that KSA 20-2909 talks about that if there are not at least 3 attorneys deemed qualified by the nominating commission who reside in the district and willing to accept the nomination, the nominating commission need not consider its limitation, it need not limit its consideration of nominees outside the judicial district. Now, I did not, given the short amount of time period from when the applications were due until now, I have not had an opportunity to get a judicial advisory opinion on what that means, because there is a double negative in there. So for at least now, I would ask you not to use as unless it becomes a problem later, as we see the votes come in, but I would prefer you not use whether someone resides in district or out of district as a qualification. Now, if it becomes later that, it becomes an issue, then I'll address it at that point. But because of the double negatives, and I'm not, I don't want to construe this statute, without getting some kind of legal opinion from the Office of Judicial Administration. So let's focus on the qualifications that we've talked about, that were set forth in the written materials, in when we call the references, and people that weren't references, I guess comments from the community and other attorneys, as well as the interview and their responses to questions in the interview and what they said, as well as the discussion that we've just had right now. Okay? So you can vote for 1, 2, or 3, but let's not go above 3. Okay, so you can have your choice. So if you would please raise your hand if you would vote in favor of sending Michael Lomas' name up to the commission. Okay, so that looks like we have 8 votes. Is that right, Shelby? Okay. Next is David Justin Bravi. Please raise your hand if you would like to send Mr. Bravi's name up to the governor as a nomination. Okay, 1, 2, 3, 4, 5, 6. Is that right? 6?
6.
Third is Matthew Levi Morris. Please raise your hand if you would like to submit Mr. Morris's name up to the governor. Okay, I see that as no vote, Shelby. Is that correct?
Correct.
Okay. And please raise your hand if you would like to send Jason Lane's name up as a nomination to the governor. We see that as unanimous, correct?
Yes.
Okay. So our votes are unanimous. We have to send 3 names up. So based on this voting, it doesn't look like there will be any other voting, because the 3 names that would go up would be Michael Lomas, Justin Bravi, and Jason Lane. And if that is how you understand the voting to have gone, can you raise your hand and let me know? Okay. So with that, I guess we have our 3 names. At this point, Shelby, will you kind of say what you're going to do?
Yes. Yeah, I will go ahead and prepare a letter to the governor that lists the names of the 3 candidates, and they will just be in alphabetical order. They won't be in any preference order. I will go ahead and get that letter along with the applications over to her office as soon as I can today. I would say that would probably happen within the next hour, hour and a half. And then a press release will go out once the governor has those names from our office, stating to the public whose names have gone up to the governor.
Okay. And a couple things. First of all, as far as the governor goes, I guess it was, I can't remember what it was John who said this or Chip, but you should feel free. Your work here now is done. And so if there is anything you want to relay to the governor, I think that would be fine if you wanted to do that. Chip, did you have a question? You stood up tall. You're on mute.
Yep. Okay, here we go. What's the time limit then on the governor's office to respond to our nominations?
She has 60 days.
60 days. Thank you.
So she has 60 days, and normally it takes a good 30 days for the KBI to run the background checks. And then she usually conducts interviews. She doesn't always, well, I should say every governor usually interviews the 3 candidates, but don't always. And then at the end of the 30-day period, the governor's office will make an announcement about who's appointed.
Thank you for the update.
Okay, and as we discussed at our last meeting, well, if you did not make any notes on the materials that you have, then I guess you could shred them. Is that right, Shelby? Can they shred them, or do they have to send the applications back to you?
If you guys did not make any notes on the applications, please just shred them. Yes.
Okay. And then do we ask them for some kind of attestation that they shredded them, or we just
take their word that they did.
Okay.
Wow, I thought we mailed them back last time.
Yeah.
I think we did, yeah.
If you guys want to mail them, I'd be glad to keep them. I mean,
well, you would probably just shred them. I mean, because we have the original copy, right?
We do.
But I don't think there's a problem with you shredding them.
No.
The only thing notes I made on the application itself was the times that I was to reconnect with the people I called. Setting up appointments to call.
Mm-hmm.
My notes are on paper, and you want those notes, I take it.
Correct. Now, those notes aren't public.
I agree.
But we are required to retain them for a certain amount of time. So,
And
Shelby, how do you, go ahead.
Can Shelby, can you give us a label to put on the envelope?
I have not done that before.
I'm not asking you to make the arrangement, but just give me a label to send directly to you.
I can do that, or just provide you my direct address.
Either one.
Okay. Yeah, I could go ahead and just send it to all the commission members after the meeting.
Okay.
And if you're shredding, if you only make notes on certain pages of the applications, you can just send those pages. We don't want you to incur a big mailing cost. Although you could be reimbursed for the mailing cost, or but we want this to be as easy for you as possible. So, John, did you have a question? Yeah. Okay. Okay. So if you took notes, Shelby's going to maybe send out an email with our exact email address. With our exact street address, and you can mail those to her, and then if you made notes on any of the applications, just send those pages, and then otherwise just shred. I think your work is done here as a commission. I do want to make a final note to let you know that we, the Supreme Court, and I think I can speak on behalf of even your communities, both legal and regular communities, so appreciate the time and energy and effort you put into this process. This is a merit selection process system. I believe in the merit process system, And you guys are volunteers. You're all volunteers. And I know it takes away from your busy lives. And I want you to know that the Supreme Court appreciates what you do. And I know that it's in the best interest of your communities and the 9th Judicial District. So thank you very much for your service.
This is Tom. I have a question about the minutes that I sent to you. And Shelby, did you distribute those to the panel?
I have not, no.
Oh, okay. Well,
Because we have to approve those minutes.
you mean that they haven't seen? Okay.
So what we'll do is send out the minutes. And it might not be until Monday because this is the second nominating commission that Shelby's had to administer in the last 48 hours. So she has, plus she's getting opinions out. So it might not be until early next week, but she will send out the minutes from our September 7th meeting. And what was it, September 7th? September
2nd.
Second, or September 2nd. And then, and she will ask you to vote on whether or not you approve those minutes.
Thank you.
One thing, Justice Standridge, before we get off the meeting today, are you going to notify the individuals whose names have gone up to the governor and those who have not? Or does Mr. Adrian do that? How has the commission done that in the past?
This is my first go around, so.
Justice Wilson did it last time.
Yeah,
Okay.
yes, I agree.
Do you feel comfortable with that, with me doing it? Okay. And Shelby, do we usually wait until the names go to the governor or do I do it now?
I would go ahead and do it now.
Okay.
Well, I'm sure there's people watching the live stream that are going to probably inform these people, but
Okay,
they'd like to hear from you.
Okay. Very good. Good question, Shelby. Thank you. Any other questions? Now remember, everybody, this is my first time. So if there's something I need to do, now is the time to tell me. Okay. Everybody have a good weekend and thank you so much again.
Thank you.
Thank you.
Yeah.